We all take precautions in life. We take every measure to make sure we and our family are safe. But when our worst fears become reality, when lives have been changed forever or worse, lost due to an accident, what next?
When something catastrophic happens to you or someone you love, call us.
When good isn't just good enough, we offer you more than a typical law firm. If you've been injured in a car accident, call us today for a free consultation at 410-814-4600 or visit us online at batesgarcia.com.
Hello and welcome back. My name is Ivan Bates and I am your host for Law and Disorder. On today's installment, we'll be talking to retired detective Kevin Turner from the Baltimore City Police Department. Detective Turner has been an officer for about 21 years. Over the course of his storied career, he was an officer in Western District, excuse me.
Yes, Western District.
Western District. He's an officer in Western District. He was an officer that dealt with robberies and eventually making his way to homicide, where we first really had the opportunity to work together. He's an officer that I've known and for a long time had the opportunity to respect, an officer that did things the right way. Today we'll talk about an important aspect of the criminal justice system. What I think is one of the most important aspects is knowing your rights. The criminal justice system is a system in which it can be very confusing. The whole purpose of this podcast and all the podcasts are to educate you to the criminal justice system. The criminal justice system is a maze and is very mysterious. However, unfortunately, the criminal justice system is one of the things that has allowed us, our people, to be what I still view in servitude. The criminal justice system is a system that does not level the playing field, and hopefully through the education of this podcast, we're able to do that. When we start out today, Detective Turner, I want you just to speak a little bit about yourself, your background, some of the things you did. What we will do for this particular podcast, we'll take a hypothetical, but it'll be a case that you and I had, right. A case involving a murder by a gentleman named Linnell Whiting. This was a case that happened back in 2001, I believe, was the murder. I was a young prosecutor in homicide, and you were the lead detective. Yes. And it was a case that we'll talk from the very inception of when it happened, what you did, my involvement, and then the investigation. And all through this entire case, we'll use this as the example in discussing knowing your rights, because it dealt with so many different people and the issues involving their rights.
Okay.
All right?
All right.
So why don't you go ahead and tell the listeners just a little bit about yourself.
All right. Thanks for having me here, Ivan.
Thank you.
I started off, after coming out of the military in 1990, joined the police department, worked in the Western District. Great place to work, great people, great crime at that time. And I went downtown and did undercover drug work with the Violent Crime Task Force, a brand new unit. Okay. We did undercover buys, we did search and seizure warrants, whole lot of street enforcement throughout the city. I went back to the Western District, joined the Western District Drug Unit, Operations Unit, and then eventually went back down to the Violent Crime Task Force when they redid the unit and made it a unit that focused on investigating shootings throughout the city.
Okay.
Then from doing the shootings in the Violent Crime Task Force, I went to homicide, off and on for a total like 13 years. Went to the Eastern District Drug Investigative Unit, Detective Investigative Unit, where they focused on shootings, robberies, rapes, and assaults, felony assaults. I trained a lot of detectives within the Eastern District, and then finished out my career in the Warrant Apprehension Task Force with the U.S. Marshals.
Okay. So, once again, this program today, the name is entitled Know Your Rights. So we want to talk about a case that we had, I guess, in 2001. It's a gentleman named Linnell Whiting was accused of murder. But do you remember the day, I guess, the call went out on this particular case?
Yeah. It was a call that we got. It was a murder call that's consistent with Baltimore City. Went there, went to the house, It was Homewood and Biddle Street, I believe it was, right in that intersection. Got there. The house was secured, which was unusual. Forced entry, I believe, was done into the house. One of his co-workers had called. He didn't show up to work, and so she got concerned and called the police, went there. The magistrate did the forced entry, but when she got there, there was no forced entry into the house, which suggested that whoever killed the victim was able to lock the door and leave. The house was in a disarray, like a big fight had broke out. Blood was everywhere. This was one of the cases where I had started doing a search and seizure warrant on a crime scene, which you don't have to do, but it's a good thing to do, which I was told that that's a good practice to get into because you never know what you may find.
Okay.
So obtained a search and seizure warrant for the victim's house, processed it, had QRT come out, and they videotaped it for me as we walked through the crime scene, the different various rooms within the house, because you could tell that the victim, he was beat about the head, the hands, defensive wounds. A lot of crime scene evidence was everywhere.
So, as you began to do your investigation, did you realize that there were pieces of evidence that were important, and how did you and what did you do when you found their importance and relevance?
Yeah, specifically the witness. Well, she wasn't a witness. The victim's friend had a lot of information about the victim. We was able to obtain his cell phone number, which was missing. His cell phone was missing. We obtained his cell phone number, and just different things throughout the house that was missing, jewelry and things like that. So with the cell phone being missing, I immediately obtained a search and seizure warrant to get all the information from the telephone. And that took us about 8 hours. This happened, we got the call at night, so I was able to get it first thing in the morning. Search and seizure warrant, we was able to get a, I forgot what it's called back then. It was an order to listen to or to get all the calls from off the phone.
Like a pen register.
Pen register, that's
Yep.
it. Pen register, that's it.
And that's still also like a warrant
It
where you
is.
have to fill out information and the probable cause, and the judge will sit down and sign it, correct?
Exactly. And so the technology was brand new back then as far as the cell phones and the tracking of the cell phones. It wasn't as it is now, pretty much instantaneously you could get the information. So I had to deal with Sprint, which was like the #1 carrier at that time. And they were sending me, faxing me all the telephone logs for their cell phone. And with that, I had to obtain the search and seizure warrant to get the information to the phone numbers that was corresponding on the victim's cell phone, to get the people's addresses and names and things like that. So the phone had went silent for like after the second day after the murder. So I concentrated on the approximate time of death that the victim was killed. Take it out a half a day and a day. So it had to be about like 15 different addresses that popped up on a continuous basis. 2 of those houses were the houses on Preston Street that belonged to 2 juveniles. Well, 2 juveniles lived there. Ran the house, got everybody's information that resided within the house.
Okay.
And with that, we did that based on the mail, BG&E, any calls to that house, any 911 calls to the house, to kind of narrow it down. So with the search and seizure warrant, it included drugs, any evidence pertaining to the murder, and or suspects involved.
Okay. So right now, I just wanted to give everybody a background into this case and to the investigation. And now we'll break it down in terms of how it applies to your rights. When you look at your rights are governed by the 4th Amendment to the United States Constitution. And that says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued, but upon probable cause supported by oath or affirmation, and particularly describing the place to be secured and the persons or things to be seized. So, Detective Turner, when you talked about getting a search warrant, the probable cause, based on the information you had from the cell phone technology, the cell phone records, and based on the fact that the cell phone was missing, was that the information you put in a warrant to try to have a judge sign to go to the juvenile's location?
Yes, I did, because the two addresses that we focused on Preston Street, were continuously using the phone shortly after the murder happened, and throughout the next day.
And so that's what the information you used to get a search and seizure warrant to go to that house?
Yes.
And you eventually went to that house?
Yes.
Okay. Now let's stop right there. Let's say that there was a patrol officer who was riding down the street, and the patrol officer just happened to see these juveniles outside the house, but the patrol officer, and they were standing on the corner, but the patrol officer did not know they were connected in any way to this investigation, even though the patrol officer is still part of Baltimore City Police Department. Can the patrol officer just walk up to these juveniles or to these, say they're adults, on the corner and just talk to them?
Yes, they can.
And do they have to? And so we'll call these juveniles. Let's call one of them Stephen. Okay. So say Stephen's one of the juveniles, and Stephen's on the corner. The patrol officer can just walk up and talk to Stephen for any reason.
Yes, he can.
And what if Stephen doesn't want to talk to this police officer?
Well, Stephen doesn't have to. I mean, he could walk away and tell the officer, look, I don't want to talk to you, or I have nothing to say.
Okay. And that's a patrol officer who doesn't know anything about the investigation.
Correct.
Okay. Now, let's say the same patrol officer has information that there's a juvenile named Stephen that the police would like to try to talk to in reference to an investigation. They have never executed a search and seizure warrant, just as a juvenile named Stephen who tends to hang out in that neighborhood. Can the patrol officer walk up and talk to Stephen again?
Yes, he can.
And does Stephen have to talk to this officer?
No.
Now, there's a case called Terry v. Ohio, and that is one of the cases that deals with what's called reasonable articulable suspicion. In Terry v. Ohio, that's a case where the officer has information that these individuals could potentially they're breaking into these stores, and this officer's watching these individuals, quote unquote, case or look at the stores, and the officer then has reasonable articulable suspicion that criminal activity is afoot and approaches these officers. And reasonable articulable suspicion is one of the most important aspects of the criminal justice system, if I'm not mistaken.
Correct, it is.
Now, if the police officer, the patrol officer has information that Stephen may have a cell phone that has been stolen in his possession, would that suffice to be called reasonable articulable suspicion that the officer could walk up and approach Stephen?
Yes, it is.
And in walking up and approaching Stephen with reasonable articulable suspicion, is the officer allowed to pat down the outer clothing of Stephen if they want to? Could they do that?
Just for the purpose of officer safety, but they couldn't go any further than that. So say like with this case, the victim wasn't shot.
Okay.
Okay. It was just blunt force trauma. That means he was just beat about the head and the body with dumbbells that was in the house or anything that the suspect could find. But if it was a shooting, and then the officer knew that, yes, the juvenile named Stephen, and that's all he had, was a possible suspect, he could just pat him down for officer safety.
And what if he pat him down and he did not find a cell phone or anything like that? Could Stephen just say, I don't want to talk to you, and walk away?
Yes, he could.
Because at that point in time, is Stephen a suspect?
No, he's a person of interest. And at the same time, the officer couldn't seize the cell phone because he doesn't know whether the cell phone belonged to Stephen or belonged to the victim.
So even if he pat him down and found a cell phone, he couldn't just take it?
He couldn't just take it, no.
So is the officer allowed to just go in Stephen's pockets?
No.
So if you're on the street and the officer sees you, they may pat you down for your safety, but they just can't go in your pockets and they just can't stop you.
No, they can't. No, they can't. Now, if you have a gun on you and they feel the bulge of a gun, then that's a whole different topic too. Now he could actually place you under arrest and seize the gun, and that's the fruits, the poisonous tree right there.
Okay. So right now we're going to go ahead and take a quick break. We'll come back and we'll talk about Stephen being on the street and the police stopping him a little bit more. But right now we're going to hear a word from our sponsor.
I'm not sorry. I'm not sorry to the guy in the car that jumped the light and sideswiped me. I'm not sorry that my serious injury, my suffering, is a problem for you. I'm not sorry there's a dent in your car. Not sorry you didn't see me. But you'll be sorry when you hear who my lawyer is.
Bates and Garcia. When good isn't just good enough, we offer you more than a typical law firm. Call us today for a free consultation at 410-814-4600 or visit us online at batesgarcia.com.
Welcome back to Law and Disorder. I'm your host, Ivan Bates, and we're here with our guest, retired homicide detective Kevin Turner. And we're talking about knowing your rights, but we're comparing it to a case that Detective Turner and I tried years ago when I was a homicide prosecutor and he was a homicide detective. We left off talking about the person in our story, Stephen, a juvenile, who the police view as a person of interest because they're looking for a cell phone that's connected, they believe, to a murder of the victim. When we last talked about this cell phone, the police could pat Stephen down in the outer garments. But I think later on, through your investigation, you're able to find out that Stephen actually was selling drugs, correct?
Yes. What actually happened is that as soon as the murder happened, we ran the checks on the phone calls that were made, and specifically targeted one. It was another female juvenile. Simply talked to her with her mother present, asked her who called her, and she thought, oh, Stephen called me and John called me. And they lived around the corner on Preston Street. Ran Preston Street address for any juveniles that was arrested, because when juveniles are arrested, we have a system that anybody that's arrested, that gives you their name, address, and phone number, things like that. So I ran a house that the young lady told me where they lived at, and was able to get the two juvenile names that was using the phone.
Okay.
Right after the murder. And so that's how I was able to get the phone number, the address, and the names of the two juveniles.
Okay.
And then with running the juveniles record, was it found out that they had numerous drug arrests within that area.
Okay.
Preston and Greenmount, Biddle Street.
So let's say Stephen and John are outside in the corner and there's an officer that sees what they believe is a hand-to-hand drug transaction, and they stop the individual who they believe purchased the drugs, and they get the drugs off that individual. But this officer doesn't know anything about your investigation. Is that what's called reasonable articulable suspicion to stop Stephen and John?
Yes.
And why is that?
Because he witnessed the crime taking place. The officer witnessed the crime taking place. And so with what he or she believed to be a hand-to-hand drug transaction, that's probable cause for the stop.
Now, let's sit down and say the officer believes there was a hand-to-hand drug transaction, feels they saw them, but they try to stop the purchaser.
Yes.
But the purchaser gets away and they never are able to stop the person, the buyer of the drugs. Is that also a reason that the officer now still has reasonable articulable suspicion to still stop Stephen and John?
Yes, it is.
Even though they never actually ever stop the purchaser and they don't know what's being sold?
Correct.
And why is that?
Based on that training and expertise that we get throughout the academy, and depending on how long you've been on the street and what you've been doing as far as your career, that is a reasonable, probable cause enough to stop and place the person under arrest.
So the police don't have to recover the drugs off a purchaser to just have reasonable articulable suspicion.
No.
So let's say they go up to Stephen or John, and is that enough to arrest them?
Based on what they saw, yes, it is.
So on the first scenario, they have recovered the drugs. So based on recovery of the drugs.
Yes.
On the second scenario, let's say when the police stop Stephen or John, neither one of them have any money on them and neither one of them have any drugs. Is that still enough to arrest Stephen and John?
No, it's not, but you could. Now, depending on the scenario, if they was dealing from a stash or you saw them come from out of their pockets or whatever. And then if you place them under arrest, no drugs, no money, it's kind of hard in court. You could do it based on your training and expertise, but it's kind of shaky at best.
Okay. Yeah. So you, as an officer, would not have arrested them. You'd have just sat out there and continue to watch.
No, continue to watch, yes.
Okay. Now, in this case, what happened to the juveniles when you were able to, during your investigation?
What happened is we got the search and seizure warrant like the very next day. It took us a day to get all the records, investigate the records, executed search and seizure warrants the next day on 10 to 15 houses throughout Baltimore City, Baltimore County. We went in there and arrested the juveniles that morning. We, inside the search and seizure warrant, included drugs, paperwork, computers, anything like that, any weapons, anything dealing with associated with murder and or narcotic dealing. Raided the house, the two houses, 2 juveniles was in there, found drugs, didn't find the cell phone. And so took them to the station, read them their Miranda rights, even though there was juveniles, their parents wasn't in the room because we didn't have to have their parents in the room because they are criminals at that time. They were locked up for the actual drug charge initially until we did further investigation to find out whether they did commit the murder and what happened to the cell phone.
Okay. So now they're taken to police custody. So the first part of the discussion, we talked about what happens if the police approach you on the street. This part of the discussion, I'd like to talk about when you're in police custody.
Okay.
Custody means what? The reasonable belief that you are not free to leave or go.
Correct.
So let's say you executed these 15 search and seizure warrants, and these 2 juveniles, there was elements of a crime in their house, meaning the drugs, correct?
Correct.
And even though you didn't find the cell phone, you still took these juveniles down to the police station.
Correct.
And taking them down to the police station, were the juveniles free to go?
No.
And why was that?
Because they was actually placed under arrest for the actual narcotics that we found within their room. Now, we took everybody that was in their house down, besides the elderly young lady. We interviewed her at the house. We took everybody down to homicide. Common practice. The 2 suspects, juvenile suspects, were placed in the room, and they were not free to go.
Now, what about some of the other individuals who were in that house who you took down to the police station? If they told you at their house, "I don't want to go," did they have to go with the police?
No.
Now, if the police come and they see you and they think you're a witness to a crime, but you don't want to go and talk to the police, do you have to go?
Not at that point in time, no.
Okay. Now, let's fast forward to when Stephen is in the police custody and he's not free to go. He's read his Miranda rights. And what are your Miranda rights?
It's simply 2 sentences. Basically, it boils down to 5, but essentially, the only thing you have to say is that you have the absolute right to remain silent. Anything you say can and will be used against you. If you cannot afford an attorney, one will be given to you, period. There's like 3 other things that we read off.
But those are the most important.
Those are the most 2 important things.
And now in your Miranda rights, they have the person here, Stephen would go ahead and read them himself and sign the document?
He would read each 5 items. Initially, I would ask him or her, "Do you understand what you just read?" They say yes or no. If they say no, then I would explain it to them until they do understand it.
Now, when Stephen's there, even though he's a juvenile, must you always have your parents with the juvenile before they can give a statement to the police?
No.
And that's the law?
That's the law.
Okay. Now, what if Stephen didn't want to give a statement, but he said, "I want my mother and father"?
No. His mother and father had to do that because he is charged with a crime that elevated him to be charged as an adult.
Okay.
Well, he could have been. The investigation's still going on. But as far as the narcotics, because he was under arrest, no.
Now, what if Stephen said, "I want a lawyer"? What would happen then?
And then we would have to stop until he has an attorney. Then we could go back and talk to him, even if it's the same day or it's 2 days later. And that's depending on his attorney.
Okay. Now, when you're down there with the police, if you're in custody, that means the police are talking to you. What if the police tell Stephen, "Hey, we have 15 people that said they saw you at the house that did the murder," but that's not true? Are the police allowed to lie or mislead an individual in custody to convince them to make a statement?
Yes.
So to me, it seems then, I guess, the best thing a person who's in police custody could really say is attorney or lawyer.
Correct.
So the only way to stop the police from asking you questions if you're in custody, you're taken down to the police station, is how?
It's just to simply ask for an attorney and don't say anything.
And so you're just invoking your rights to counsel.
Yes.
All right. And once you invoke your right to counsel, what does that mean? Can they continue to ask you regular questions, but they just don't ask you anything about the crime? What does that do?
Yeah, we can ask you regular questions like if we don't know, like your middle name, place of birth, simple biographical questions that we can put on an information sheet just for our record keeping purposes.
Now, in this case, the juvenile gave you a statement, correct?
Yes, they did.
And based on the information that you received from this juvenile in the statement, what were you able to do with that?
Well, I was able to continue the investigation was going on, and then we eventually knocked on 10 other doors after the investigation because it was found out that the juveniles bought the cell phone from an individual on the street that they only knew of a nickname.
And based on that nickname and that information, were you able to hunt down that person?
Yes. We actually got to a house in Baltimore County that the witness knew the suspect, and because the suspect had called him shortly after the murder also.
Okay. And then were you eventually able to make your way to the suspect in the murder?
Yes, we did. We did a photo array with the person of the witness in Baltimore County and with the two juveniles who said that that's who they bought the phone from.
And then based on that, was that eventually a suspect in your murder case?
Yes, it was.
And what did you do when that person was your suspect? What did you do?
We obtained an arrest warrant for him, locked him up eventually, brought him into the homicide headquarters, and he was interviewed, and he gave a statement.
Okay. So the juveniles were just people of interest, correct?
Correct. Eventually, they turned out to be people of interest after we talked to them and clarified how did they come into possession of the cell phone and what they did with the cell phone after that.
Okay. And then, based on their statements, you were able to develop a suspect.
Yes.
And when you had a suspect, you brought this person down to the police station.
Yes.
Now, even though that person was a suspect, what if he didn't want to come to the police station? He had done nothing wrong criminally that you had seen. Was he still forced to come to the police station?
Yes, because actually we had obtained an arrest warrant for murder for him prior to him getting arrested. So, he was not free to go.
Okay. So once you have an arrest warrant and that person is there giving a statement, 9 out of 10 times, you're not, no matter what they say, they're not going to not be charged with murder. Am I correct?
Correct.
So once he was down in the police station, did he make a statement?
Yes, he did.
And based on that statement, did it corroborate some of the things that you knew already?
A very little bit on how he met a couple of witnesses, but he always denied that he didn't do the murder.
So based on his statement, do you think that him giving the statement helped him or it hurt his case?
It hurt his case because we had a lot of DNA evidence that kind of put him at the crime scene.
And so his statement, you were able to say that he lied to the police.
Correct.
Okay. Now, right now, we're going to go ahead and take a quick break. And when we come back, we'll continue with the case and we'll talk a little more about your rights. But I guess we're getting to the point now. We're about to meet up, you and I, in the case.
Correct.
We'll talk about the trial. But we're going to hear right now from our sponsors. And once again, my name is Ivan Bates, and this is Law and Disorder with our special guest, retired detective Kevin Turner.
We all take precautions in life. We take every measure to make sure we and our family are safe. But when our worst fears become reality, when lives have been changed forever or worse, lost due to an accident, what next?
When something catastrophic happens to you or someone you love, call us.
When good isn't just good enough, we offer you more than a typical law firm. If you've been injured in a car accident, call us today for a free consultation at 410-814-4600 or visit us online at batesgarcia.com.
Welcome back to Law and Disorder. I am your host, Ivan Bates, and we're here with our special guest, retired detective Kevin Turner. We left off, we were talking about a homicide case that you were investigating. And we talked about how your rights are involved. We first talked about being on the street when you're approached by the police. Then we've also talked about when you're in custody. And we're also discussing how this case comes about and when the police do an investigation. We're at the point now where you have information, you've now charged Linnell Whiting in the murder, and you come across a young state's attorney.
Yes.
And do you remember coming across that state's attorney?
I sure did.
Who was that state's attorney?
That was you, Ivan Bates.
So back then, I was a brand new, wet behind the ear prosecutor. And we sat down, we went over all the information. And it's a very circumstantial case, and you just put all the pieces and laid all the pieces out there together.
Yes.
And one of the most important pieces was the interview of the suspect, Mr. Whiting.
Yes.
Now, it wasn't just Mr. Whiting that you had to interview, but you also had an interview from Mr. Whiting's friend / lover,
Yes.
Crystal.
Right, correct.
And Crystal was able to tell you about the bite, a human bite that the suspect, Mr. Whiting, had where he was bitten by the victim. And I believe you also found Mr. Whiting's DNA on the victim, correct?
Correct.
So talk a little bit about that and what that did in reference to the case and comparing that information to the statement that Mr. Whiting had given you.
Okay, because like I mentioned earlier, it was a very violent murder where the victim worked out, had a dumbbell set there with a weight bench. And from what the crime scene showed, the suspect was in the house visiting the victim, social setting that went bad. I mean, the suspect wanted to rob the victim. The victim had money, lived alone, and and how he killed the victim is that he picked up the dumbbells and just began beating the victim about the head. The victim fought back. He had defensive wounds on his fist. He bit the suspect, as it later came out from talking to Crystal, that we were able to get the DNA. Correction, we did the casting of the victim's mouth, matched it to the wound on the victim, and other DNA within the house, able to tie everything together, even though the victim said that, yeah, he was just there, but then he left.
Yes. Now, also from what I remember about the case, the victim had a television set was missing, and other electronics that were missing, and Crystal told you where they were living.
Yes.
It wasn't an actual house. They had kind of squatted in a location, correct?
Correct.
Even though they were squatting, and it wasn't an actual house, did you still need to get a search and seizure warrant to go into that actual location they were squatting in, even though it technically, one would argue, wasn't legally their house?
Yes, I did. Because when someone takes up residency, whether they live there or not, the court still have a right to that area that they live.
So they still have a reasonable expectation of privacy.
Correct, yes.
So based on the information that you were able to get from Crystal, you were able to put that in a warrant and have the probable cause to go in there. And you were able, I think, to find the television from the victim's house, correct?
Yes, correct.
And based on that, Crystal testified against the gentleman, Mr. Whiting.
Yes.
And you were able to use Mr. Whiting's statement where he wasn't truthful against him as well, correct?
Correct.
So if Mr. Whiting had just said he wanted an attorney, you would not have been able to use his statement against him.
Correct.
Okay. So at the end, based on the DNA, based on the testimony from Crystal, based on the testimony from the juveniles, based on the testimony, I think the medical records of the victim, and all the other myriad of evidence, we were able to secure a first-degree murder conviction and trial against Linnell Whiting, correct?
Yes, we were.
And now Mr. Whiting is doing life plus 20 for the murder, correct?
Yes.
So, when you look at this case, there's so many nuances because we discussed how your investigation came to be. We discussed about all the different people that are players. Some of them at one time appeared to be suspects, but they had their own criminal issues.
Yes.
And how just talking to the police or doing other criminal activity can lead you in the crosshairs of the police sometimes.
Correct. Yes.
Now, the last area of your rights I'd like to talk about is knowing your rights when the police stop your car. Hypothetically, in this case, say the juveniles are riding down the street in their car, and it's their parents' car, they're riding down the street, and the taillight is out. Even though you are gathering the information for the juveniles to stop to go to search their house and their cars or anything like that their parents may own, but the police officer, the patrol officer doesn't know this information. But the patrol officer sees this car driven by the juveniles has a taillight that's out.
Okay.
What can the police officer do?
He could stop them for that traffic violation.
And in stopping them for the traffic violation, what does that look like, and what are their rights?
Well, they have to pull over, of course. The officer will walk up. He or she would say, can I have your license and registration? And at the time, you have to produce your license and registration. I mean, you can ask the officer why they stopped you. He or she doesn't have to say why they stopped you, but 9 times out of 10, they will. They'll be like, look, your left tail light is out, or you failed to stop at a stop sign, or you made a right turn without coming to a full stop.
And can a police officer require, in this case, Stephen, could he make Stephen get out the vehicle if he's driving?
For officer safety, or if he or she sees something that want them to get out of their car. Now, with this case, if they knew that he was a possible murder suspect, then they may have him get out of the car just for officer safety so they could get a full view of him.
Okay. But let's say in this car, we know based on the search and seizure warrant that Stephen had drugs in his house. But let's say the officer sees a plastic bag, Ziploc bag with brown substance on the floorboard of John, and
Yes.
say John, the other juvenile, is right in the passenger seat. At that moment in time, can the officer have both John and Stephen get out the car?
Yes,
And why is that?
because it's called constructive possession. At that point in time, the officer don't know who the drugs belong to or suspected drugs belong to.
So is that reasonable articulable suspicion that criminal activity is afoot, and that's when the reason the officer can ask them to get out?
Yes.
Does that mean the officer can just search the car without a search warrant?
They could search incident to the arrest. So if they lock both of them up for what he or she appears to be suspected narcotics, then they could lock them up. And yes, they could search the vehicle without a search and seizure warrant.
And that's because they can search their lunge, reach, or grasp in terms of the people in the vehicle, correct?
Correct. The front part of the vehicle or the back seat, yes.
But the officers just couldn't pull them out the car and run to the trunk and pop the trunk if they hadn't found anything illegal?
No.
Now, let's say the officers find that this is a bag of marijuana. At that moment in time, is that probable cause to search the entire car?
Just the inside. Well, you could search the inside of the vehicle, and if you're going to tow the vehicle, you could search the entire vehicle.
The trunk?
Yes.
Okay. So you could do that also because now you've searched incident to arrest?
Correct.
Now, in searching the vehicle, let's say the police only smell marijuana, but they don't see anything right away.
Right.
Is that still a reason to have these Stephen and John to get out the vehicle?
I mean, you can have them exited, but excuse me, based on the marijuana laws of today, it's kind of they can have it for medical use, and depending on where you are, it's recreational, so you can have it, a small portion thereof, depending on what the weight is.
Okay.
So, but for Baltimore City, for the conversation that we're having now, you could have them get out of the vehicle just for officer safety
And the officer would be allowed to then go and search the interior of the vehicle because they smelled marijuana?
No.
But let's say that the officer said, oh, I smell marijuana, and then just went in and pulled you out and searched the vehicle. What should you do? I mean, because you're feeling that it's illegal, do you yell and scream and just say you can, or do you just let the officer do what they're going to do?
No, just let the officer do what he or she's going to do. Note the badge number and the name, and then go straight to depending on what happens, go straight to the police station, speak with the supervisor.
Okay.
That's if you're not arrested. But anything that they find based on an illegal search and seizure, then should eventually be thrown out of court if they get a good attorney.
Okay. So just because a mere car stop your vehicle stopped does not necessarily rise to the level of an arrest, correct?
Correct.
And that's more or less just a car stop and they stop you. That's called custodial interrogation for the purposes of Miranda warnings. Do they have to give you Miranda warnings just because they stop you?
No, they don't.
But let's say if the police then find the bag of marijuana or they find a handgun in the vehicle, and then at that moment in time, if you're arrested in terms of custodial interrogation, at that moment in time, must there be Miranda warnings?
No.
What about they arrest you?
Mm-hmm.
At that moment in time, should you just say anything or should you just keep your mouth shut?
No, you should just be quiet at that time.
So when the police pull you over in your car, you need to just be quiet. And if the police give you Miranda warnings, you should always say, attorney, correct?
Correct.
All right. Well, now we've sat down and discussed these three aspects. We're going to take another break, and we'll be back in a few.
I'm not sorry. I'm not sorry to the guy in the car that jumped the light and sideswiped me. I'm not sorry that my serious injury, my suffering, is a problem for you. I'm not sorry there's a dent in your car. Not sorry you didn't see me. But you'll be sorry when you hear who my lawyer is.
Bates and Garcia. When good isn't just good enough, we offer you more than a typical law firm. Call us today for a free consultation at 410-814-4600 or visit us online at batesgarcia.com.
Hey, welcome back to Law and Disorder. I'm your host, Ivan Bates, and we've been here talking with our special guest, retired Baltimore City homicide detective Kevin Turner. We have discussed the Fourth Amendment, what it means to you and knowing your rights. We've discussed it from the point of view that the police approach you as you're on the street, walking down the street. The police know you're involved in criminal activity, and the police don't suspect you being involved in criminal activity. We've talked about being in police custody, what that means, your rights as a suspect, and your rights as a witness. We've also discussed if the police stop you in a car, potentially as a suspect and potentially just a regular car stop. Now, we'll finish up, and I just want to ask you a couple questions, Detective Turner.
Okay.
With the car stop, once the police have written you a ticket, at that moment in time, if the police officer gives you the ticket for your taillight being out, and they don't see anything in plain view, and they say, hey, I'd like to go ahead and search your vehicle. At that moment in time, should you just allow the police search your vehicle, or should you just take the ticket, say, thank you, very officer, I decline, and you're free to go?
You should just take the ticket and say, no, I don't want you to search my vehicle, just leave.
Now, what would be your words of wisdom to your son or daughter in interacting with the police if they're stopped while in the car?
I would say keep your hands in plain sight on the steering wheel. Comply with the officer. Don't try to dispute was the stop legal or what you did or what you didn't do. A lot of times if you're courteous and just let things flow, you'll get out of there probably with a warning, if that, and possibly no ticket. You know, you just have to be courteous and just go.
So say there's an aggressive officer. What's one of the things you should do if the officer is aggressive? And what's one of the most important things that you would tell your son or daughter to do?
Comply and try to get a badge number and or name. I mean, in the age of the video with the cell phones, if you have somebody in the car, you could try the video just to make sure everything is fine. The iPhone now has a feature. If Siri knows that you're stopped by the police, she'll automatically record it. So that's something that you could do. But then again, the whole thing is don't dispute it in the street with the police.
Okay. And in closing, if there's one thing that I would want everybody to know, when they're stopped by the police and the police are asking questions, 9 times out of 10, the police already know the answers to the question. You're not going to be able to talk yourself out of being arrested. So the most important word that you know is attorney, lawyer. Every single one of my clients, I tell them there's a lot of pressure. You're afraid. Most people are afraid of being involved with the police, being in custody, having the police ask questions. When you want it to stop, the only thing you say is attorney. Don't write anything. Don't tell them anything. Just say, I need a lawyer. I want my lawyer. And once you say lawyer, what does that mean to a police officer?
Stop all conversations pertaining to that particular crime.
Exactly. Well, thank you very much for being our special guest. It was a great opportunity working with you back in 2001, 2002. I do feel that we did a good job with that case. The young man had a fair trial, and we were able to bring justice for that family and for his friends.
Yes, exactly.
The criminal justice system is very confusing, but we wanted to hopefully educate you, the listener, a little bit about the things that an officer does in putting together a homicide case, how your rights are intertwined within the case, and making sure that you know your rights from the time period you may be stopped at your house, stopped on the corner, the police execute a search and seizure warrant at your house, you're stopped in the car, you may be brought down either as a suspect, a witness, or a person of interest to the police station. Most of all, and most importantly, please take the time to know your rights. And if you feel that you don't want to say anything at any moment, any second, any time, just say, I want my lawyer. And then they have to stop. Thank you once again, Detective Turner.
Thank you.
And on behalf of Mr. Pierre, our producer, everybody at DMV Daily, my name is Ivan Bates. Follow me on Twitter at Ivan J. Bates. And thank you for tuning in and listening to Law and Disorder.
We all take precautions in life. We take every measure to make sure we and our family are safe. But when our worst fears become reality, when lives have been changed forever or worse, lost due to an accident, what next?
When something catastrophic happens to you or someone you love, call us.
When good isn't just good enough, we offer you more than a typical law firm. If you've been injured in a car accident, call us today for a free consultation at 410-814-4600 or visit us online at batesgarcia.com.
Law and Disorder with Ivan Bates is produced by Andy Pierre and brought to you by the DMV Daily Media Group, Maryland's leading podcast network, offering you a wide variety of informational podcasts and programs, including the award-winning daily program, the DMV Daily Radio Show, which airs Monday through Friday from 5 to 6:30 p.m. only on DMVDaily.news. You can find out more information on this podcast and on other podcasts and programs produced by DMV Daily by simply going to the website, www.dmvdaily.news. Be sure to follow DMV Daily Radio on iTunes, Stitcher, TuneIn, and Google Play, or watch episodes on the DMV Daily Show on Facebook, Periscope, or YouTube at DMV Daily News. You can also donate to this independent news outlet by simply going to paypal.me/DMV Daily News.